So we're recording this. Anybody who doesn't agree to want to be recorded and videoed, it's going to be difficult. You should take your picture down if that's your wish. But you've granted permission by signing on. All right, so I'm going to introduce our three panelists by name, and then I will read their short bios as it's their turn to speak. The format's going to be that each one will speak for about 15 minutes, and then we'll go back around again. If you have comments or questions, please put them in the chat, and Aviva and I will look at them, and we'll introduce your questions. Everyone's going to stay muted except our speakers. So here we go. Our speakers are Ann Luzine, Steve Elrod, and Todd Vandermeed. Ann Luzine I've known since I was a young man. She has done many things, including a career of teaching as a professor at UIC Law School, which I still finally refer to as John Marshall, its former name, since 1975. I've known Ann even before that, when she was in charge of the Civil Service Commission in Illinois. And she also acted as a research assistant for the 6th Illinois Constitutional Convention in 1970, and a staff assistant to the Speaker of the Illinois House of Representatives, who, believe it or not, was a Republican back in 1971. She was a parliamentarian of the House for 2 years. Her specialty is the Illinois Constitution. When she worked at CONCON, she was asked to write research memos on the federal right to bear arms, the relationship to the state constitution and statutes. At that time, the conventional wisdom was that the Second Amendment would never be incorporated into state law. The convention proposed Article 1, Section 22, which is the Illinois right to bear arms. Her topic today is the relationship of the Second Amendment and the Illinois right. So, Ann, go ahead.
Okay.
15
First,
minutes.
let me say that the Second Amendment to the United States Constitution reads as follows: a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. The commas are there to indicate a slight pause to the person reading the text aloud. It was assumed that a lot of people, being semi-literate or illiterate, needed to have the new Constitution and the amendments read aloud to them, and so they would put in hints there as to when you were to pause, and that was the commas. We don't use commas the same way that today. Now you notice it says the people. It's not an individual right, as is the case in the Fifth Amendment and some other amendments. It is a general right in the people. Arms may or may not mean swords and clubs, as well as firearms, shooting bullets. We are not sure, because firearms in the sense of something shooting bullets were actually very erratic in those days. So a lot of people defended themselves with swords and with clubs. Nobody knows for sure what the constitutional framers envisioned. It is pretty obvious that most gentlemen, high-ranking men, wore dress swords in public. A number of families kept firearms at home, over the fireplace. And indeed, many people who were going on trips outside of the home carried firearms with them, as well as non-firearm weapons. Some cities, notably Boston, required that all gunpowder be stored in a centrally located warehouse. And that was because if a fire started in a home, you could have gunpowder going off, sort of like 4th of July firecrackers. So they wanted to put it all in one warehouse. That meant that most people defended their homes with non-firearms. They had bullets, they had swords, they had knives. Now, we don't know what the Second Amendment means. Everybody's got a view, as you know, but I'm telling you what I know so far about the Second Amendment. Now, let me say something about the 1970 Illinois Constitution and its background. At that time, the conventional wisdom was that the Second Amendment was not incorporated to the states via the 14th Amendment and probably never would be. Now, that was a theory. Would it ever be? Well, it certainly wasn't at the time. It would take another 40 years for that to happen in the Heller case and the McDonald case. So now you had in 1970 an issue. Do we need a right to bear arms in the Illinois Constitution? We had not had one before because nobody thought it was necessary. The legislature didn't really do very much about firearms. I'm talking about something that shoots bullets. Obviously, there were a few rules, like a convicted felon upon being released from prison cannot be in possession of a firearm at least for so many years. And nobody objected to that. However, in 1969, just as the delegates were running for Concon, something happened in the legislature. At the request of Governor Ogilvie, the Illinois General Assembly decided to pass a statute requiring all people who had firearms to register them. This is the FOID card, the Firearm Owner's Identification Card. Now, the impetus and the push for this particular statute came from law enforcement officials and from legislators from the city of Chicago. Now, this created a divide in the state in 1969. Many downstaters, especially those who live on farms, thought this was, quote, the camel getting its nose into the tent, close quote. If they can enact a firearm registration act, they can regulate as to who can own a firearm beyond the obvious thing that people who are convicted felons probably shouldn't be carrying them. So a number of delegates from downstate ran on the campaign platform of elect me and I will try to get a right to bear arms into the Illinois Constitution. Now, what we ended up with was something that's not really like the federal amendment. Article 1, Section 22 reads, right to arms, subject only to the police power, comma, the right of the individual citizen to keep and bear arms shall not be infringed. You notice it says the individual citizen, not people. Now, I'm not sure what difference this makes, but it means that it's individuals and it says citizens. I think that this means that people who are not United States or at least not Illinois citizens are excluded from a right to bear arms. But obviously, I'm not sure. The litigation we've had has obviously come from people who were clearly residents of Illinois. The legislative history suggests arms means only firearms. They weren't really after swords and clubs and so forth. Some downstate delegates, as I say, had run for this. It was an absolute divide over the entire state. Now, within the city of Chicago, delegation, you had the independents and you had what were called the regulars, those who were sort of part of Mayor Daley's organization. All but one of the Black delegates from Chicago were members of the Daley organization. And they were somewhat ambivalent about this, as I recall. They felt they did not get good police protection. A number of them felt, obviously, that the police were sometimes antagonistic to Black people, but at the same time, they needed the police. And then they said, well, sometimes we need to have guns in our homes because we aren't sure we could get the police there in time to prevent a disaster. Now, this has been true. People don't realize this about the racial divide here. Remember that Otis McDonald, who brought the 2010 case on the issue of incorporation in McDonald versus Chicago, He was an African American. He died about 4 years ago. He was a retired University of Chicago security guard. He lived in a predominantly African American neighborhood in Chicago, and he said the police could never get to my house in time. And that was his view. And that is the way I have heard from a lot of my friends who are Black Chicagoans. Not to mention Black people I know who grew up in the South who said if we had a firearm in our house and we had a couple of sharpshooters in the family, we felt that the Ku Klux Klan would be less likely to bother us. Now, I'm just telling you what I heard. Now, many African Americans had this view, but now you get to the white people of Chicago and the Chicago suburbs, that's even more so. They said, what do we need with a firearm in the home? And now you start getting this divide here. You all know, because you've talked with people about this, a lot of people who had businesses, especially small businesses in Chicago, said, absolutely, I want, especially liquor stores, jewelry stores, which were often being hit. They said, if we keep a firearm behind the counter, anybody comes in and starts creating a problem, I'll blow his head off. I mean, these were different views. In the end, as they were coming out with what was to be the language, a couple things happened. First of all, there were rumors, which I'm not going to repeat the details of because I don't know what's true, that there were some deals being made, that the Daley delegation, which means probably old Mayor Daley, behind it really wanted to get some kind of way here to get something, use this as a bargaining chip with the downstaters. So it was we'd like to have something and we'll give you downstaters a right to bear arms. There are questions about what it was Daley wanted, or if this deal even took place. I don't know. Obviously, I was not part of the negotiations. We don't know what happened, but one of the people who was part of the Daley delegation was Paul Elward, a state legislator who later became a judge. And Paul Elward stood up one day and proposed that police power language, subject only to the police power. Now, obviously, as lawyers, we know the police power means, health, education, welfare, that sort of thing. And it would be there anyway. There's a police power rubric that is involved with every one of the federal amendments and all state amendments. But he said, I think that this should be the police power. Now, some people, including quite a few outside of the convention, actually thought this meant that only the police could carry guns. So there was a lot of confusion going on. But this was enough to get a kind of a compromise. We can regulate guns somehow or another. That was obviously what Elward was after. But there is some kind of a right to bear arms, and it is for the individual citizen, which may end up becoming very important in a future litigation. Obviously, there could be reasonable regulations, but what is a reasonable regulation? And I can't even offer an opinion on this, 50 some years later, everything changes. Now, the relationship between the two provisions, the Second Amendment and Article 1, Section 22, the relationship is debatable. The wording is different. People, individual citizen, militia is missing in the state provision. Should the independent principle of interpreting state constitutions apply here? My view is always yes. My view is it's a state constitution, it's for state courts. They should not necessarily look to the federal rights, but remembering that the federal right sets a floor for any constitutional rights discussion. But do you interpret the state provision in lockstep with the federal right? Now, as you all know, the Illinois Supreme Court has a tendency, which I frankly deplore, I've said so openly to their faces, of what is called the limited lockstep doctrine, where they always seem to think that whatever the United States Supreme Court says about federal amendments really is more than persuasive in interpreting what they consider to be a similar type of right. But this is completely different language. Now, we really don't know what they are going to do. They tend to skirt the issue, I gather. Now, something new has just happened. The state of Hawaii, through its state Supreme Court, on February the 7th, 2024, came up with a blockbuster decision called the State of Illinois versus Wilson. There was a statute in Hawaii that prohibited the carrying of firearms in public. There were the usual exceptions and everything, but they prohibited. And Wilson wanted to carry firearms in public. And so after a big discussion about standing, the Hawaiian Supreme Court said on the 7th of February that their particular language in the Hawaiian Constitution may be identical to the federal one, but we don't care. Now, it's rare you hear a state Supreme Court take on SCOTUS like that. Now, the Hawaiian Constitution, Article 1, Section 17 says, it's a copycat of the Second Amendment, says, ignoring the commas, of course. A well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Now, that is to all intents and purposes identical to the Second Amendment. This begs for a lockstep doctrine, right? No, not in Hawaii. And if you read the opinion, if you want it, I can get you the citation. It's out in slip opinion, of course. I can tell you that, boy, the language. I mean, you don't hear this very often. I mean, they practically started calling the United States Supreme Court names. They don't know what they're doing. And then they said, this is Hawaii, we're interpreting the Hawaiian Constitution the way we want to interpret it. And, well, I'm just not going to repeat the language. That's all there's to it.
And you need to wrap up, Ann.
Okay, I don't know. But the one last sentence. The devil is in the details here. And the devil is in the cases interpreting the state rights. So I don't know what my colleagues are going to say, but I have a feeling that we may be seeing something now where they start interpreting the Article 1, Section 22 language, which is different from the Second Amendment, a little differently from the Second Amendment. I mean, look what Hawaii has done.
So, Ann, I just want you to know there's been 2 comments in the chat praising you and remembering you as a fine professor.
Very sweet. I'm
And
not changing grades. That's all there is to it.
That's right. Okay, so our next speaker is Steve Elrod, and he represents private and public sector clients on land use and local government matters. He is the co-founding partner of Elrod Friedman LLP and serves as the firm's managing partner. Prior, he was the partner in global law firm Holland and Knight LLP, where he served as executive partner in the Chicago office. He's past president of the Chicago Bar Association and currently serves as the corporation counsel of the city of Highland Park and a village attorney for the villages of Deerfield, Glencoe, Lincolnwood, Northbrook, among many others. He's also a proud member of the Decalogue Society. He's an adjunct professor at Northwestern University Pritzker School of Law, where he teaches land use and local government law. His undergraduate was at Tulane, and he graduated magna cum laude. Steve drafted and successfully defended a federal court challenge to the city of Highland Park assault weapons ban ordinance and the state court challenge to the village of Deerfield assault weapons ban ordinance. He was also present at the Highland Park event. Steve drafted and successfully defended, oh, they did that one already. Chambers USA 2023 law firm rankings for real estate land use placed Steve in the highest ranking category possible for an individual attorney in Illinois. So here you go, Steve. You got 15 minutes.
All right, thank you very much, Cliff, and Professor. That was amazing. What a great history lesson. I appreciate all of that and learning all of that, some of that for the first time I've heard it. I'm going to take you all sort of picked up a little bit where Ann left off. I'm going to fast forward a little bit and focus on assault weapons. Primarily, I have a unique perspective on assault weapons, being a drafter of assault weapon regulations, being a litigator defending assault weapons in the state and federal courts, and being a victim of an assault weapon shooting, as I was an attendee at the 4th of July parade in my hometown. But this is a CLE, so I'm going to talk primarily from my perspective as a municipal lawyer. And I'm going to take you to 2012, when the state of Illinois was in a little bit of turmoil concerning concealed carry. At that particular point in time, the state of Illinois was the only state in the country that didn't allow some form of concealed carry. And that led to litigation and an admonition by the Seventh Circuit. It's Moore versus Madigan. It's the one case that we don't have cited in your materials. It's 702 F 3rd 933. It's a 2012 Seventh Circuit opinion that generally held Illinois, the prohibition in Illinois of any kind of concealed carry was unconstitutional. And the Seventh Circuit gave a mandate to the district court to enter a declaration of unconstitutionality against Illinois, which would have left Illinois with no regulation at all concerning the carrying of guns in public. But they stayed that mandate for 180 days to allow the Illinois legislature to craft some new gun law that would impose reasonable limitations consistent with the Second Amendment. So there was a lot going on in Springfield after that ruling in late 2012 and during the 180-day period till about June of 2013. Then Governor Quinn was pushing for a statewide assault weapon ban that ultimately failed. The NRA and the Illinois Rifle Association was pushing for a very liberal, basically unlimited concealed carry law, which was somewhat difficult. And the legislators, in their infinite wisdom, ultimately crafted a concealed carry act that had a number of compromises in it. There was no statewide assault weapon ban in 2013. They amended the existing FOID Act that Ann talked about, the Firearm Owners Identification Act, and they added a firearm concealed carry provision that allowed the concealed carry of firearms, but with a license, but not in certain what they call prohibited areas such as schools and parks, and any private property that had a posted door sign. But was very interesting and is going to where I'm going to focus was a provision that was buried pretty deep into that hundreds of pages of legislation. There was a new section 13 that was a local government preemption concerning firearm regulation. First, it prohibited local governments, including home rule, from adopting any regulation of handguns or ammunition for handguns. Not too significant because, as I'm sure Todd will point out, the United States Supreme Court already made that the law of the land in the United States. But it also prohibited local governments, including home rule governments, from regulating the possession or ownership of assault weapons. Incidentally, it did not prohibit the regulation of the sale of assault weapons, and the city of Naperville later picked up on that just a couple years ago. The state declared that the regulation of assault weapons, of the use and possession, was the exclusive power and function of the state, something that the state is able to do under the home rule provision of Article 7, Section 6 of the Illinois Constitution. Even though the state didn't adopt any regulation of its own, it basically preempted the field by that declaration. But interestingly, the statute also contained a very curious first time I've ever seen, and most municipal historians have ever seen, a very curious and limited grandfather provision. It said, even though we're prohibiting local regulation of assault weapons, local assault weapon ordinances that existed as of the date of adoption of this statute in 2013, or those that are adopted within 10 days after this law becomes effective, would not be preempted, would be exempt from preemption. So Cook County and Chicago were among the few governments in Illinois to have an existing assault weapon ban. They were grandfathered. I presume that was one of the bases for this preemption. But this 10-day window caused a great deal of scurrying by local governments throughout the state. I had various experience with the many local government clients that our firm represented at the time, reacting to that 2013 statute. Some chose not to adopt any regulation at all. Others could not act quickly enough. 10 days is a tough time. Many local governments, particularly suburban governments, meet only once or twice a month. So it was pretty difficult to do anything within a 10-day window. The city of Highland Park, one of our local government clients that we represent, was one of the handful of home rule communities that was able to get its act together. It had strong leadership and a strong city council that wanted to adopt legislation within that 10-day window, and it adopted a full ban on assault weapons and large capacity magazines. I'll come back to the Highland Park ordinance in just a moment. I want to also mention another one of our clients, the Village of Deerfield. It was not prepared to go all the way in 2013 within that 10-day window, but it did want to do something. So it adopted a regulation, not a ban. It required safe storage of assault weapons. Then later in 2018, after the mass shootings in Las Vegas and Parkland, Florida, Deerfield amended its regulation to a full ban. There was a lawsuit filed against Deerfield in state court, basically a home rule challenge, saying that the amendment in 2018 was not an amendment at all. It was actually complete new legislation. Therefore, it was outside of the 10-day window and should be nullified. That worked its way through the state courts in Illinois, and the Illinois Supreme Court ultimately affirmed a second district Illinois appellate court opinion ruling in favor of Deerfield. So the Deerfield assault weapon ban, as amended, was allowed to stand. Highland Park's ban was met with an immediate Second Amendment challenge in the federal court by a local resident, Dr. Ari Friedman, and the Illinois State Rifle Association. I'm going to talk briefly about the constitutional issues in the Highland Park case, but I'm sure Todd will go into greater detail about the overall constitutional matters. When we drafted the Highland Park ordinance, we looked carefully at the District of Columbia versus Heller case, and I know Todd's going to talk about that. That case struck down a DC law prohibiting handgun possession. But Justice Scalia, who authored that opinion, famously added two limitations to his general proclamation that the Second Amendment protects an individual right to possess handguns. Those became known as the Heller exceptions. First is the whatever, wherever exception that said, and this is Scalia talking, it should be understood that the Second Amendment's not unlimited. It shouldn't be understood as a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. He noted that there's a longstanding prohibition on possession by felons and mentally ill, and forbidding guns in places like school. And he also noted what has become known as the dangerous and unusual exception. He said that the Second Amendment does not protect firearms that are dangerous and unusual weapons and not in common use. And he noted machine guns. So when we were drafting Highland Park, we gave careful consideration to those teachings, and the Highland Park City Council made a legislative determination that assault weapons and large capacity magazines are dangerous and unusual weapons, are not traditionally used for self-defense in the city, and do pose an undue threat to public safety. In the lawsuit filed in 2013, Ari Friedman and the Illinois Rifle Association claimed that the Highland Park City Council was overreacting. And this is a quote from the complaint in their brief in the United States District Court. A mass shooting has never happened in Highland Park and likely never will. Therefore, this court should dismiss or find invalid the Highland Park ordinance. Well, the court did not do that. The court, the district court, Judge Dara, found that the Highland Park ordinance was constitutional, and the Seventh Circuit in 2015, in a very strong opinion issued by Judge Easterbrook, of all judges on the Seventh Circuit, honed in on the right of a local community like Highland Park to be concerned about its public safety and more important, its public's sense of safety. They validated the Highland Park assault weapon ban, and the United States Supreme Court refused cert in December of 2015. After that decision came Bruin, the New York State Rifle and Pistol Association versus Bruin. Todd, I'll let you discuss that, but basically that case allowed for a two-part test in reviewing assault weapons, known as the text and history test. It appeared to put the burden on governments in defending assault weapons. It struck down a New York concealed carry regulation, and it opened the door to more regulation in Illinois. Indeed, in 2022, the National Association for Gun Rights NAGR filed two lawsuits in Illinois. One against the city of Naperville, along with a gun shop owner by the name of Robert Beavis, and the other against the city of Highland Park in September of 2022, just 2 months after the mass shooting at the Highland Park Independence Day Parade. Both were filed hoping that, based on Bruin, the state of Illinois courts or the Seventh Circuit would review the assault weapon ban differently. While those cases were pending and working their ways through the federal courts, the Illinois state legislature in January of 2023 adopted the Protect Illinois Communities Act, which is the state's version of a ban on the possession, manufacture, and sale of assault weapons. The challenges to that state action, along with the Naperville litigation and all of the other downstate challenges, and a challenge to the Chicago assault weapon ban, and the and a new challenge, the Cook County assault weapon ban, were all consolidated together into the Seventh Circuit case of Beavis versus Naperville. The only one that was not consolidated into it, interestingly, was the Highland Park litigation. But we ultimately succeeded in getting most of that complaint dismissed on our motion to dismiss. And just a month ago, the remaining plaintiff voluntarily dismissed the remainder of the case with prejudice. So that's over. But the Beavis decision, and I'll end with this, is very important and very interesting decision authored by Judge Wood in the Seventh Circuit, decided just this past November, noted that the Naperville ordinance and the state of Illinois statute are not constitutionally infirm, do pass muster under the Second Amendment, and do pass the Bruin test. They believe it passed even the first prong of the Bruin test, which wouldn't have even allowed it to go on to the second prong, but they did anyway to further demonstrate that these statutes and the statute and ordinances are constitutional, basically affirming the Friedman versus Highland Park case that was decided years earlier. Just a quick note that in December, the United States Supreme Court declined a request to enjoin the enforcement of the Beavis decision, and just recently a petition for writ of certiorari was filed with the United States Supreme Court. So it's not over, and I'm sure, as Todd is going to explain, there's a lot of argument on the other side, to which I will respond after he's done. Thank you.
Thanks, Steve. So our third speaker is Todd Vandermeide. He's a retired operating engineer from Local 150, because all those labor unions are always close to my heart. Todd was a contract lobbyist for 30 years. He's often referred to as the Illinois gun law guru, as you can see by his beard. Todd served as the NRA contract lobbyist in Illinois for over 25 years, consulted and represented manufacturers and dealers, as well as holding a Type 07 manufacturers. What's FFL? What's that?
Federal firearms license.
Oh, okay. For a decade, allowing him to manufacture such items as suppressors, short barrel rifles, and machine guns, as well as other retail sales. He was the driving force behind several lawsuits: Gowder versus Chicago, Illinois Firearms Retails versus Chicago, Lawson versus Chicago, Shepard versus Illinois. The latter lead to Illinois' passage of a concealed carry law. He is the lead plaintiff in the challenge to the Cook County gun and ammo tax, Vandermeed versus Cook County. Largely retired, Todd now consults on firearms and two-way litigation, serving as vice president of the Second Amendment Law Center in California and the Second Amendment Defense and Education Coalition here in Illinois. Both groups support an ongoing effort to protect the rights and keep the bear arms. Todd is responsible for developing an amici brief in the Cargill case and before the Supreme Court, and is instrumental in the challenge to the Illinois ban on semi-automatics. A resident of Yorkville, where he resides with his wife, 2 dogs, whose names I'll keep anonymous in case somebody's going to hassle them and protect their privacy, is the creator of the Freedom Steel YouTube channel, where he comments on Second Amendment legal issues. So here you go, Todd, 15 minutes.
All right, let me hit the timer so I don't make sure I don't run
I'll
over.
remind you in 15 or so minutes.
Thank you very much. So how'd we get here? In 2008, a landmark case called Heller versus District of Columbia came about because Dick Heller, a security guard, wanted to own a handgun, and the District of Columbia had a prohibition on handguns. It went to the United States Supreme Court, and at the United States Supreme Court, they found 3 basic things. The first holding said that the Second Amendment protects an individual right to possess a firearm unconnected with the service in a militia, and to use that arm for traditionally lawful purposes, such as self-defense within the home. For the last, 15 plus years, people on the other side of this argument have attempted to write out those 2 words, such as. The court did not limit the possession of firearms or other arms to self-defense. They used it as a description for all traditionally lawful purposes, such as self-defense within the home. I think that is the most valued and protected portion of the right. And if you think of it as a series of circles on a target, as you get out, the right may diminish some. But they also said a couple of other things. The amendment's prefatory clause announces a purpose, but does not limit or expand the scope of the second part, the operative clause. The operative clause text and history demonstrate that it connotes an individual right to keep and bear arms. Oftentimes in this debate, the people that don't like firearms or want to regulate them out of existence say, well, you keep forgetting about the first part. No, we have not forgotten about it. The court has implicitly said it doesn't expand or contract from the second part of it. They said a couple of other things. And part of this will go to the semi-auto ban challenges here in Illinois, because on page 8, the court went on to say, some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And that'll come back here in a second when we talk about Friedman some more. But the court went on, and the sad thing was that for ever since Heller came out, you had lower courts, inferior courts consistently ignoring the pronouncements of Heller. In 2010, Otis McDonald filed a challenge with the State Rifle Association, the Second Amendment Foundation, before the ink was even dry on Heller, challenging Chicago's handgun ban. Chicago's handgun ban came about because in 1982, they took a registry. If you wanted to have a firearm in Chicago, you had to register it. And what they did is they closed that registry for handguns. You could not register any new handguns. It was done under Jane Byrne. It remained that way up until 2010 when the Seventh Circuit, in their opinion, said they did not have the ability to incorporate the Second Amendment. Only the Supreme Court did. McDonald went up and the Second Amendment was incorporated, and Heller was reaffirmed with Justice Alito writing that opinion. McDonald then gave rise to a new Chicago ordinance that attempted to instill their own licensing of people who could own firearms within the city limits. And it was met with a great deal of resistance. Not only did they try to license individuals vis-a-vis a super version of the FOID card, they tried to prohibit gun dealers, they tried to regulate sales, they tried to prohibit ranges, they tried to prohibit all kinds of individuals who are not prohibited under state law. That gave rise to a series of challenges. One of those challenges was Gowder v. Chicago, which was Sean Gowder, a personal friend of mine that I helped out in this. Mr. Gowder had a Class A conviction for a UUW, a misdemeanor back in the day because as a black man living in Inglewood, he carried a gun for his own personal protection. And back in the day, before the Cervantes single subject ruling out of the Illinois Supreme Court, it was typically a Class A misdemeanor before 2000 in order to, if you got caught carrying a gun. And so they were trying to prohibit anybody with a weapons conviction from being able to own or possess a firearm. Mr. Gowder challenged that and prevailed in the Seventh Circuit at the district court level. Their prohibition against firearm retailers was challenged in the Illinois Retail Firearm Association challenge, and the city lost on that as well. The bigger case that came out of that era was Ezell. Rhonda Ezell was an individual who wanted to obtain the quote Chicago license, and because of that, everybody that wanted a Chicago license had to go and take range training, live fire range training. At the same time, the ordinance in Chicago prohibited any ranges from opening within the city limits. And Ezell becomes important for it dovetails now into the Bruin methodology that the court adopted a little over a year ago. So what happened was there was a Zell 1 decided by the Seventh Circuit Court of Appeals in 2011. There was a Zell 2 decided in 2017. And the basic parts of Zell talks about organizational standing, and organizations like the State Rifle Association, the NRA, Second Amendment Foundation, all have organizational standing to bring challenges to these laws. Standing is usually a big argument that happens, but I think Ezell is pretty clear that any of the organizations can bring a claim on behalf of their members. The other parts at Ezell really, because we always hear in some of the litigation about the current gun ban in Illinois, there's no right to sell a gun. Patently false. Illinois Retailers Association and Ezell both say that there is a right to acquire. There cannot be a right to acquire if there is not the corresponding right to sell, whether it be in a commercial transaction or in a private transaction. And the other takeaway from Ezell was it went on to say that the ban on ranges, you can't do that. Just as they couldn't ban gun shops, you can't ban ranges, especially when you're mandating mandatory training as part of the condition of obtaining. And it didn't matter that there were ranges in the suburbs or that somebody might be closer to a range in the suburbs than any range that could open up in the city of Chicago. And because of that, the ban on ranges was struck down. And they said that you have a right to train and maintain proficiency. And that becomes very interesting and important with the New York decision. So the city then tried to zone ranges out of existence and led to only 2% of the property or land in Chicago being eligible, and the court in 2017 threw a lot of those zoning restrictions out, including a 500-foot setback. So you fast forward a little bit to around 2012, and there was a challenge by two groups. You had the NRA challenge in Shepherd v. Moore, and then you had the challenge of SAF and others in, I'm sorry, Shepherd v. Madigan, and then you had Moore v. Madigan, which were two different challenges to the Illinois state's ban on carrying a firearm. Now to back up to for the Chicago McDonald litigation, there was a case against Oak Park that NRA had. And with it, at the end of the day, the city of Chicago ended up paying our attorneys $1.2 million over the litigation on the McDonald case. And the city ended up paying attorneys' fees on all those other cases because they eventually ended up repealing their Chicago ordinance. So then you end up with the Seventh Circuit taking up the issue of carrying a firearm outside the home. And with that, once again, our side prevailed on that. And it was not appealed to the Supreme Court by the state. The information we had was that there were a series of anti-gun groups that said, look, we've only lost Illinois. If you take this up and the court accepts it, we lose the country. That's why it took so long to get a national carry case, because they were trying to find the right case. So then in the interim in 2015, you end up with Friedman, a challenge to the Highland Park semi-auto ban. It's very interesting for what Friedman does. The court just recently in the Beavis case said Friedman is still good law, although this is where I have given Justice Easterbrook the nickname Frivolous Frank, because if you go back to what the Supreme Court said in Heller, some have made the argument bordering on the frivolous, only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. And yet Justice Easterbrook wrote in Highland Park and Friedman, the features prohibited by Highland Park's ordinance were not common in 1791. Most guns available then could not fire more than one shot without being reloaded. Revolvers with rotating cylinders weren't widely available until the early 19th century. So here you have Friedman cutting directly against what the court published in Heller. And I would point out that Heller went on to say that there was to be no interest balancing, that the interest balancing was already conducted at the time of the ratification. So in Friedman, the court went on to say, if it has no other effect, Highland Park's ordinance may increase the public's sense of safety. If a ban on semi-automatic guns and large capacity magazines reduces the perceived risk from a mass shooting and makes the public feel safer as a result, that's a substantial benefit. I think that at that point in time, it wasn't even intermediate scrutiny. It wasn't even rational basis scrutiny. It was down to something well below that in order to justify the Highland Park ban. So we fast forward almost 15 years later, from the Heller decision, we have New York State Rifle and Pistol Association v. Bruin, which was a challenge to the May issue permitting regime in the state of New York. And the court found that that permitting regime was against the Second Amendment, that the discretionary nature of it was against the Second Amendment. And they said that the courts for the last 15 years had been getting it wrong with this interest balancing approach. And what they said is it's a new test. Interest balancing is out the window. And with that, they said that first you look to the text. And if the text covers the conduct, then the conduct is presumptively presumptively protected. And we move to step 2, and the burden now shifts to the government to prove that whatever regulation they're seeking to enforce is presumptively lawful based on history and tradition of our country. And you can't just go find 3 ordinances or something from the territories from 1791 or even up until 1868. You have to have something much more convincing, because they have repeatedly thrown out those types of analogies. And that has led to Illinois pass their challenge, or their gun ban. And there are a series of challenges that are working their way. You had the Naperville challenge, you had the Highland Park challenge, you had the Herrera challenge. Then you had the 4 cases down in Southern Illinois. The FFL case I'm a part of is a little more nuanced, because all the other cases challenged guns and magazines. Our case challenges guns, parts, the right to repair, and registration. So we're taking a slightly different approach to it.
So if you could wrap up, you're just about out of time, or a little over.
So when New York was pending, as it came down, there were 4 cases waiting on cert. There was a Hawaii case on carry. There was the Duncan case out of California dealing with magazines. There was the New Jersey magazine case, and then there was Bianchi, a challenge to Maryland semi-auto ban. All 4 cases were GVR'd, granted, vacated, and remanded to the lower courts to try again, see New York. And that's where we are today. The court has heard arguments on Rahimi, a case dealing with domestic violence and a federal statute there. There's a cert petition for range, a nonviolent felon. There are a number of semi-auto bans, including Bianchi, pending. And so we have a whole bunch of stuff waiting to hear on how the court's going to rule. Any questions?
I have some questions from the audience, and then we're gonna go round again, and let you all comment on them. So let me,
Cliff, before we get to the audience questions, I see what they are. I just have a direct response to 2 issues that Todd raised.
let's wait. Let's be sure we incorporate these questions first, and then I'll let you all respond, if we could. So, there's been several questions about this Morton Grove handgun ban repealed in 2007. And then some questions about subject only to police power, what Ann had cited. And let's see, I think that's pretty much it. So if you want to incorporate any of that into your responses, and then we'll let we'll let Ann start first, and then Steve.
I know why Paul Elward did this. He wanted to emphasize you could have reasonable regulation. I talked with him about it years later, and he said, you have to have some kind of regulation. Come on. But the truth is, I don't know what subject to the police power adds in here. You could say the same thing about every other right. Has that been litigated very much, you guys, Todd and Steve?
It was litigated in Quillisi, and it was litigated in Calademos, and both cases came down on the side of the government and basically said that initial phrase, subject to the police power of the state, has all but neutered anything that follows that. So that's why you will never see anybody on our side today arguing anything about Section 22 or under the state constitution. We just won't touch it, because the courts have literally neutered it and made Section 22 irrelevant.
Steve, did you have a comment on that, and Ann's question? Okay.
Not on that one, no.
All right, so then on Morton Grove, if
Yeah.
any.
So Morton Grove was very famous for having one of the first ordinances, certainly in Illinois, maybe even in the country, that banned the possession of handguns.
First in the country, Steve.
In the country, yeah. So it was actually litigated in Illinois and upheld by the Illinois Supreme Court in the early 80s. Morton Grove then repealed its ordinance post Heller and post the Illinois state legislative action in 2013 that made it unlawful for even home rule municipalities to have a ban on handguns. Todd, I mean, I think it's as simple as that. Yeah.
Look, you're absolutely right.
Yeah.
They repealed it based on Heller, because they saw what was coming down the pike with what came out in Heller. And I don't think they wanted to be on the losing end of a big bill like Chicago saw,
Right.
for their litigation.
Post Heller, so just in Illinois, post Morton Grove, when Morton Grove's ordinance was upheld, many other local governments filed adopted similar enactments, thinking that it was lawful. Heller came down. A lot of municipalities kept their bans of handguns on the books. They just didn't do anything. They realized it would be invalid. That was risky because you could suffer a facial challenge and be subject to 1983 damages. But then when the state of Illinois adopted its law in 2013, a number of local governments amended their codes and took the legislation off the books.
Yep.
Steve, did you have another comment you wanted to make?
I just wanted, Todd, I love hearing you speak. I know we've talked before. You're a wealth of knowledge, but I just take issue with the characterization of Judge Easterbrook as frivolous Frank. We were actually surprised in Highland Park that when we learned that Easterbrook was the judge on our panel and issuing the decision, because he is a very recent judge and not necessarily, I wouldn't consider him to be in the liberal camp. And when
Oh no, I in general, no. When it
No,
comes to this issue,
so
absolutely.
when he issued, you share my sentiment. So you can imagine what we in Highland Park.
I am generally not scared. He scared me.
So
I was never more fearful.
you can imagine how we felt when we heard that he was authoring the opinion. But I think his opinion is anything but frivolous, and I do think that Judge Diane Wood, who I have a great deal of respect for, and who doesn't always see eye to eye with Judge Easterbrook, as you all know, those that follow the Seventh Circuit, could see how strongly she endorsed several years later the Friedman versus Highland Park opinion when she authored the Beavis versus Naperville opinion. So I want to take issue with you on that, Todd. And one other comment that you made, just about organizations, the standing issue in organizations bringing a claim on behalf of its members. Be careful after the recent Highland Park case, when one of the national gun rights associations, NAGR.
I know who they are.
Okay, well, they don't know very many people in Illinois, apparently, because they couldn't find anyone in Highland Park that was a member. Not even the Susan Goldman, who was their co-plaintiff, was a member of NAGR. And the United States District Court threw out their case based on standing, saying that they had nobody that they were representing. So if you are going to be a member organization and file a lawsuit against the local government, be careful.
I think that's a perfectly valid point, Steve, when you're dealing with a small organization like that. When you're talking about statewide groups here in Illinois or other groups like the National Rifle Association that have millions of members, or FPC, I think the standing issue is a little different. When the state is trying to knock us out for standing, whether it be the FFL organization or GOA or SAF, I think it's ridiculous. That issue in that context has been settled. But as far as what you're saying, when you have that minutia, yeah, I think there's an issue there. But generally, I think it breaks to our side more than not.
Two simple things. One is the easy question is Nathan Hakimi wants to know how to spell Quilici and Kelgamos.
Kaladiemos? Hang on, give me a second.
Quilici and Kalodimos.
To the
That,
K.
tell that Grinnell education.
Okay. I do have one question to ask Todd and Steve. Judge Easterbrook spends much of the year at his vacation home in Alaska. I've been to Alaska. Everybody
Everybody has a
carries a
gun.
gun, and you have to have a gun in your home because the bears and the other things come around and they go searching for food. And if they can't find food, they go after a local human being. I've got to wonder, would you guess that maybe he keeps a firearm in his kind of rural home?
The question is, does he need an AR-15 or a military grade weapon to
I know,
defend his home?
that's
That's the
a-
question.
Yeah,
I don't think so.
Does he keep a firearm? I don't know. He might if he spends that much time up there. I take issue with what Steve, tries to decide as a military grade weapon because none of the guns that are being talked about are actually that. You have military specifications, military standards, which deal with tolerances, materials, and specifications for the production of those. But if you take that term military grade, you can outlaw anything. Remember that muskets were the military grade firearm of the day. The Remington 700 bolt action rifle, which a lot of hunters use, and the Winchester Model 70 bolt action rifles were those that are the basic platforms for sniper rifles used by the United States military. You have pump action shotguns going back to the 1897
Right.
Winchester being used in the military. So military grade is a fabricated term used to try to conflate something. If
It's
you
used
want,
to describe, it's used to describe weapons that were designed for military use. And the question is, for purposes of common self-defense, which I will acknowledge has been allowed under the United States Constitution, is a weapon that can shoot 83 rounds in less than 60 seconds necessary, is a weapon that is designed to melt through a military helmet necessary for common defense? That's the question. And
well, yeah, but the question's wrong because it's not necessary. The question is, it's a right. Did the Nazis have the right to go march in Skokie and speak?
Wait,
They had the right to. Well,
wait. Let's stay away from that. Okay, let's
okay.
to the other subject.
It is the Bill
Let's
of
bring it
Rights,
back-
not the Bill of
Let's
Needs.
bring it back. Let's bring it back to a law question. And did you see Michael Strom's question about Thomas Killigan's article?
Thomas Callaghan, yeah.
Did
I
you-
knew Tom Callaghan. I could never understand his point. He regularly thought that the convention was being run by communists. He made out a list once for the press of all of the delegates who were out and out communists and those who were fellow travelers, and everybody was a communist except him. And every now and then he would say, "You are establishing this right to revolution." I'd forgotten it until this was asked. I don't know, I've forgotten what Callaghan wrote years ago, but I never could. He was on the Bill of Rights Committee. He believed in a right to bear arms, but I really don't know what the man was thinking when he would write these things.
Okay, I don't know. Okay, but that pretty much answers Michael Strom's question, I think. All right, so let's go around again. Ann, did you have anything else to add to what's been done so far?
I now understand better why we don't get Article 1, Section 22 litigated. You know, if people who are challengers aren't going to bring it up because they think that they'd run into trouble with the L-word language, now I understand that better. However, what I do have as a question is, where on earth are we going with all of this? Does any of you think that the Illinois Supreme Court is going to say lockstep doctrine for Article 1, Section 22? Whatever the Supreme Court says is in the Second Amendment, we'll say that's the same for Article 1, Section 22. I have that as a question. I don't know. I don't litigate this.
I don't know because we're not going to litigate it that way. What we're going to do is we're going to take the Supreme Court decisions from Heller, McDonald, Catano, and New York, and we're going to force them upon the state. We're going to force the legislature to acquiesce to that floor that you alluded to in the beginning, and we're gonna litigate all of that. Now, one of the interesting things that I did in researching Section 22, Ann, was if you go back through the debates, you know that we have Section 6, which deals with the right to privacy.
Yes.
It is our version. So in the colloquy between the delegates, it sat there and said that one of the delegates asked, said, did you ever contemplate putting subject to police powers in front of Section 6? And the delegate had to sit there and contemplate and said, we never did. They have never.
Probably that was Bernie Weisberg who was defending Article 1, Section 6 to the
I would have to go back and I've got the
Yeah,
transcripts.
yeah.
But the funny thing there is that Illinois has an implicit right to privacy in its constitution.
Oh, yes.
If anything is going to be litigated, the things like the registration components and things like that may be litigated under Section 6, because the delegates actively said they'd never contemplate the interaction of those two sections. And when
No,
you
Tommy,
one delegate would say that, and I'll tell you, one thing about the debates is sometimes those were set up questions from the floor. You know, the person defending it would say, I want you to ask me these questions so we can establish a
I'm familiar with
record.
the tactic.
Well, fine. I mean, it's, I used to do that when I worked for the legislature. I had questions. I wrote the questions. I wrote the answers. Okay. But the thing is, there was a debate over whether even to have Article 1, Section 6. The argument being at the time that the Warren Court had created such a lovely right to privacy. Why should we put it explicitly in so many words into the Illinois Constitution? And it was Bernie Weisberg, among others, who said, we don't know what's going to happen in the future. We want to have it here in Illinois explicitly. We better put it in explicitly. And wasn't that prescient?
And I always have wondered, when they had these debates and they recorded all those minutes, were they an actual transcript of the debate, or was it?
Oh, yeah. It's a verbatim transcript. It's a pretty accurate transcript. Sometimes they misspell words, but other than that, it's pretty accurate. Yeah. The thing is, I wrote my first law review article about this called Constitutional Intent, the Illinois Supreme Court's use of the record in interpreting the Illinois Constitution. And I said, part of the difficulty here is, a lot of times when people were really talking to each other, they were talking to each other in the back of the room. They were not making a record out on the floor. And we all know that. We talk in the back of the room a lot. And a lot of lawyers get settlements by talking in the back of the room, And that's part of the difficulty. But it is the verbatim transcript. And I will say it is very valuable to look at.
Steve, did you want to say something?
No, I love that comment. I'd like to get talk in the back of the room incorporated into legislative history. That would change everything.
Oh, I said that in my law review article. I said the author used to hear conversations in the back of the chamber that were in fact more useful than what was going on out on the floor in the microphone. But those are unfortunately not recorded.
I used to love when I would get some question on Illinois Constitution, and of blessed memory, I'd call Dawn, and I'd say to my opponent, no, that's not what they said at the Constitutional Convention. And I'd call her and I'd say, so do you remember what you said at the Constitutional Convention? She said, yes, and I agree with your position, Cliff. And I would always love it that
She'd be embarrassed.
Yeah, the opponent would say,
I never said that.
It wasn't really Dawn Clark Netsch. I said, yeah, it really was. So
yeah, it really was. Yeah.
Do it for you, though.
But that's, now, of course, the legislature has a verbatim transcript of the debate since July 1st, 1971. And that's interesting to listen to, too, for the same reason. I mean,
So-
what is legislative intent? And that is
That's-
another
that's
CLE.
Yeah,
Right.
I'd love to bring you right to these cabinets behind me. You know, at Northwestern, I took over Dawn Clark Netch's municipal law course. That's what I teach. And I have all of her handwritten notes, all of her lectures, and I hold them up to the students. They're great.
They're great. Yeah.
Yeah.
I miss her.
Do I.
Anytime you want me to come and confuse the students, Steve, I'll be happy to come.
That would be awesome. I'd love to have Todd come, not for confusion, for education.
You
Well,
know,
Todd, well, I have one question. Why didn't you go to law school?
uh, because by the time it became something to think about, I was too old and I didn't have, I don't have a college degree. I don't even have an associate's. So
Well,
just,
we've
you know-
had, Ann and I have had students who, well, some of the students we've had over the years, I had a student who was 72 years old when he started law school.
yeah,
And he said, I said, but you were a retired doctor from Cook County Hospital. Why are you doing this? He says, I never wanted to be a doctor. I was a doctor for my mother. I always wanted to be a lawyer.
I've sat second chair at the Illinois Supreme Court in defending the transportation law under Diggins. And I told I said, I'm not an attorney. They said, no, we want you here. Okay. That's why I consult on a bunch of the stuff, because I look at it very differently. If you look at our case in FFL, we're challenging the right to repair. So I view my job now that the 27 words of the Second Amendment are to be made to look like the Encyclopedia Britannica, that everything that I can cover under that. So if you look at it, if you take Ezell says, I have the right to maintain proficiency. I have the right to train with my firearm. That is covered
Yeah.
under the Second Amendment. So now, if I have the right to train with my firearm, I have the right to keep my firearm in good working order so that it's safe and usable. Therefore, Illinois' ban on parts cannot stand, because I have to have the right to obtain the parts to keep my firearm in good working order. Now, if I have the right to maintain my firearm, do I have the right to assemble my own firearm because I have the skill and ability to assemble parts, put it together, and build my own firearm? It's a natural outflow from that. After that, if I have the skill, ability, and tools, can I manufacture my own firearm for my own personal use, not commercial, but for my own personal use? I think the answer from all those flows is yes, because if you go back to 1791, the original Springfield Armory, didn't start making muskets until almost the ratification of the Constitution. During the Revolutionary War, they were building cannons for the most part. And with that, what you have is a history and tradition in our country of either importing firearms from abroad or going to small local blacksmiths and making their own firearms and of the like. And that's why if you look at some of the cases like Range, like Rahimi, that are coming up under the history and tradition side of it, I think it bodes very well for us on a number of fronts. I think that the FOID card is on its last legs, because there was no general permit to own or possess firearms subject to the state back in 1791. And whatever there was when they were enacted around the adoption of the 14th, 15th Amendments, were all Jim Crow laws to try to keep the freedmen from being able to own firearms. So I'm very optimistic about where the litigation is going to go. I think our Judge McGlynn down in Southern Illinois has written a fabulous order about how he expects the litigation to proceed. Now, you have Bianchi pending at the Supreme Court. You just had Viramontes, a challenge to Cook County, get a final judgment. I expect that case is going to race to the Seventh Circuit. And they might even argue we don't even need orals, just do it on the briefs, get us a quick lose, because now Viramontes would leapfrog everything else as final judgment and be up pending, because we all know SCOTUS doesn't like to take stuff on an interlocutory a lot of the time. They prefer final judgments. You can see whatever Wood and Easterbrook are going to write under, that sort of thing. And I don't mind losing at times, just lose fast so I can get up to the Supreme Court and get the stuff nailed down. I
Of
think we've
course,
got
of course, you feel that way with the current composition of the Supreme Court. You may not have felt
Well,
that way 10 years ago, but
let me make another point here. I mean, I'm big on state constitutions, and every state has a different approach, and the cultures are different. I tell my students in my Illinois Con Law seminar that a few years ago, in 2017, I think, I was up at the Mayo Clinic, and I went over to get a manicure and pedicure. And the woman who had a sharp implement over my naked foot started talking with me about a right to bear arms. And I said, oh, it's a very interesting topic, looking at the knife. And she said, she said, my son and daughter-in-law do firearms training for young people. I said, that's very nice. What was I going to say? And she said, they have a 7-year-old and they take her out and she goes hunting with them. I said, a 7-year-old with a gun? And she said, yes, she got her first trophy the other day, meaning she shot an animal. I said, she shoots? She said, oh yeah, she's been shooting since she was 5. And all I could think of is, 1, there's a knife over my foot, and 2, a kindergartner with a firearm. And then I thought, this is Minnesota. If they feel that's okay, she said, her parents are standing right there every time she has a loaded firearm. I thought, I'm not getting into this. All of the cultures are different.
Hope
We
she
got
never
50
gets mad at her
states.
parents.
Huh?
Hope she
Her
doesn't get.
parents are standing there. Apparently, Minnesota says a child of any age, a 5, a child of any age whose parents are standing there may shoot a firearm.
can I just make a comment concerning something that Todd said? It truly frustrates me, and I find it just so ironic. Todd, I listened to your argument about if it says X, well, then I should be able to do Y, then I should be able to do Z, then I should be able, and this interpretive approach is just fascinating. It's normally attached to a more liberal view of the Constitution or interpretation of the Constitution, yet the strict constructionists who take a very strict approach for every other constitutional argument are suddenly willing to be very liberal in viewing the Second Amendment. There is just, it is truly unfortunate, in my opinion, that somehow an amendment has been elevated to be holier than every other amendment and every other provision of the Constitution. And when it comes to interpreting that amendment, the rules are different than interpreting every other amendment. And I just think that is unfortunate. And I fear that that's where we're going with the current composition of the United States Supreme Court. And it's no surprise that, Todd, you and your cohorts are anxious to get cases up to that Supreme Court.
Yeah.
Let me also say, Todd, you and I are white people, all 4 of us are. And Black friends of mine have very frequently said to me, you have no idea what it was like to grow up Black in Mississippi. And if you didn't have a gun in your house, you were, especially during the Jim Crow time, you were asking for trouble from the Ku Klux Klan. And I think some of us, I'll have to admit, don't really appreciate any of that. So that's why maybe I kind of understand where you're coming from.
And let me just say, in terms of appreciating something, as I said at the very beginning, I approached the Second Amendment and I approached assault weapon bans as a drafter, as a corporation counsel, as a litigator. I thought I appreciated it, but then when I stood at a parade and with my 5 and 4-year-old grandsons were shot at by somebody with an AR-15, I had a whole different appreciation.
I know what you mean.
Sure, to your question, Sean Gowder was a black guy, and a friend of mine who I wanted to help defend, so he had the same rights. Ida B. Wells once said that the Winchester rifle should have a place of honor in every black family's home. So it's not, I just happen to be the guy that's doing some of this, but we work with all different kinds of groups about it. And I said during the concealed carry debate that the people that need it most may not be the people out in the suburbs, but the people on the inner city, because they've had
Yeah.
a poor education system. They've had a poor police response at times. They've had a poor response from city government in general. And I think Judge Posner in the Shepherd and Moore cases sat there and said that those people down there may need more protection than the guy living behind a gated high rise on the Gold Coast.
Sure.
Well, and so I think there's been that. However, to what Steve has said, the litigation in Illinois over the gun ban, it's a lot broader than that, because Illinois is one of the few states that actually attack 22s. So a 22 squirrel rifle falls under the auspices of a so-called assault weapon in the way that it's been defined. I think that goes to how far broad. My carry gun falls under the auspices of a so-called assault weapon in the state of Illinois. So, the problem is this is going to continue, because on one side there has been a large overreach. And I think that when people said, well, we only want the FOID card, we don't want to register guns, we only want this, background checks at gun shows, it's never been enough. And every time they come back to take more. And I think that's why you were seeing a more absolutist position within the litigation world to nail down as much as possible, to just put the other side in a smaller and smaller and smaller box that they don't have anywhere to go. I mean, hopefully, maybe the state doesn't care because they're playing with free money, but Chicago, the McDonald lawsuit cost, just the NRA side of that cost Chicago $1.2 million. I don't know how much the bills are racking up on 5 different cases that the state's going to have to pay out on. When I think we ultimately prevail on this. I think we've got about another 18 months to go in litigation. But if the state wants to drag it out and force all the experts and all those other fees, that's a case. But this is just a tip. You're going to have litigation on the FOID card. You're going to have litigation on any, you've got magazines coming out of California where they got a favorable ruling. You had the district court favorable on the gun ban that was put. You just had billy clubs go on out there. I mean, this thing is going to be litigated for the foreseeable
Again and
future.
again. It's a,
So we have a question. What is the legal argument against gun registry so the responsible party can be identified when a gun is used in a crime?
It's
I
none of
think
the state's
this
damn
one
No
is-
business.
valid argument.
This is from our eminent director, right? Aviva.
Sure. Our argument is it's none of the state's business. It's our right to privacy.
But
I don't know, let him finish. I want to hear this.
Go
Todd?
ahead.
No, it's my inherent right to privacy. I've complied with the goofy laws of Illinois to where I have a FOID card. You check me out. You run my name through a database 360 days a year to make sure I don't have any new criminal disqualifications or I haven't been admitted to a mental hospital. You then sit there and say that if I buy something, either privately or retail, I have to go through another background check. And after all of this, that's not enough. You now decide you have to come into my home and track every purchase, acquisition, or sale I make, regardless to a firearm.
It's
And
not-
Todd, I
that's
just
not
have
the
to,
point. Wait. That's not the question she asked. She asked about what's wrong with or good or
And-
bad if the registry is there and then someone commits a crime and they can catch them because it's registered to them.
That's
Cliff,
what
he
the law
argued- Cliff-
enforcement people said in 1969. That's all I can tell you.
right,
Cliff, he
but
Todd
remember,
responded.
a registry in Chicago was used to create a gun ban. They shut down the registry, and that's how they got a gun ban. So since it's been abused every time it's been tried, our side will never agree to it.
Yeah,
Okay,
Todd responded
legal.
that it was his right to privacy that justified his argument against having registries. So fascinating. And it goes back to my other point. Suddenly the right to privacy is very important to Todd and his cohorts and to justices on the Supreme Court when it comes to the Second Amendment. Where is that same right to privacy on other vital issues that the court has been decided? And I look at Roe versus Wade and Dobbs.
Well, I'm all for a right to privacy, as it gets expanded out there. I think that Clelo, the one on using thermal cameras, I think the DNR should be held to that under search and seizures, that they're not because of the curtilage stuff. I'm a very big advocate of the right to privacy on any one of a number of fronts. It just happens to be another argument for us to use in our litigation. In the way it is, you asked the question was asked why. That's why. And I will point back to Jane Byrne, 1982. The other side wanted, we just want to know where the guns are. They used that to create a ban. So their own actions have told us not to be trusted, governments not to be trusted, and it's none of your damn business.
Oh, guys, you're going to love what I'm about to say.
Sure.
This is going to get bigger and bigger because in 2028, we're going to vote again on whether to hold a con. And there are so many issues where the pro side on it, like abortion, all of those issues, and gun control, all sorts of issues. The pro side and the anti side hate each other. They won't talk to each other. And some of them have been telling me we're gearing up to try to get a convention so that we can get in, and fill in. And it's both sides of the gun issue, Todd and Steve, both sides.
And I will vote for you to be on that constitutional convention.
No. I do not want to be a delegate. I want to be the queen. I have often said, even on television, only if I can be the queen of the convention, and I mean absolute monarch.
I'll vote for you for that.
All right, well, I think we're just about done. So this has been quite exciting and well argued, I thought, and everybody was fairly polite. So any other comments from the three of you before Aviva puts out the poll?
A thank you to you, Cliff, and to Aviva for organizing it. I appreciate it very much. And thank you to my fellow speakers. I very much appreciated the opportunity to speak with both of you.
Yeah, I've appreciated it. Real quick for Steve, what do you think is going to happen with Rahimi and Cargill?
The facts are fascinating, and Rahimi, I think my side wins on that one, Todd.
I think they will find that Mr. Rahimi is an absolute scumbag.
Right.
And they will rule against Mr. Rahimi. However, I think they are going to put a serious set of handcuffs on the use of those types of statutes, because the Solicitor General even said that it needed to arise to felony level conduct. And I think that the ex parte type laws that have been out there may be on some very, very shaky ground. If it's a short opinion, Gorsuch writes it. If it's a longer opinion, I predict Barrett will write it. And I think the government loses Cargill.
Todd, you should have gone to law school.
Yeah,
I would
really.
love to have you as a student.
I would have probably loved to be there. If you want to see some of my other thinking, FFL, SADEC, Second Amendment Law Center put together an amici brief in the Cargill case. That was something that I worked on. And I got your email. I'll send you my stuff on the privacy stuff. You can take a peek at some
I'm
of
putting
that.
together a list of people I might start inviting to my class. We get fights, in the seminar. Students are all over the place, honey. You'd be a prize. We'd love
You know what?
Wait,
Stop by my YouTube channel.
The thing I struggled with was I hated most of it, and I hated it because it was so anti-union, but that's a long time ago. I don't know what it's like now. All right, Aviva, are you ready?
Yeah, yes, I'm ready. And I want to thank everybody for coming. And I want to thank our presenters. This was a great class. We were hoping it would be exciting and initiate a lot of discussion, and it did. Thank you all so much.